My name is Deborah Salisbury, and I am a dependency defense lawyer. Primarily, I also happen to be a nurse practitioner with a master's degree in psychiatric nursing. And I'm going to be presenting to you today, along with Mr. Kelly, who will be handling the evidentiary issues, Michael Kelly, who also defends parents. But I also represent grandparents, children. I represent a variety of people in the dependency court arena. But today I'm going to be talking to you about advocating for children and families with complex medical issues when medical child abuse accusations are made. And we're seeing more medical child abuse accusations made across the United States because of the complex medical issues and needs and some of the child protective doctors that are getting involved in these cases. And some of the children that have complex medical issues and needs, they come in with a complex presentation of multiple symptoms. The symptoms can be a moving target. The child may present with a stomach ache, pains here, pains there, and it may be a traveling, moving type issue. These illnesses are often progressive illnesses, and they're often rare illnesses that affect these children. And rare diseases, there's about 7,000 of them. So when you get a case like this, I want you to bear in mind that the child protection team doctor is not an expert in 7,000 different rare disorders. And it affects 350 million people worldwide, these different diseases. I'm going to talk about some of the newer diagnoses because I've been in nursing for many, many years, and I had not heard of some of these things before. Mitochondrial disease, has anybody ever heard of that? Mito disease? Okay, a few people. Dysautonomia, which is an umbrella diagnosis that covers autonomic nervous system disorders. Postural orthostatic tachycardia syndrome, it's called POTS. Complex regional pain syndrome. Mast cell activation syndrome. Ehlers-Danlos syndrome, chronic fatigue immune dysfunction syndrome, and I'm sure some of you have heard of that. That's just a few. I've pulled off of the Dysautonomia website, it's called Dysautonomia International, some information about POTS disease, just to give you an idea of what goes on. Trying to get a diagnosis of POTS disease, there's usually a 4-year average diagnostic delay. The kid will go from doctor to doctor to doctor trying to find out what's wrong with them. Many of the doctors don't recognize these diseases and what's wrong with the child. It can be diagnosed as simply as a 10-minute diagnostic test, but if the doctor isn't picking up on what's wrong, they're not going to do that test. And it affects many, many different systems of the body. And I'm just talking about one disease. I'm not here to educate you about all these different diseases today, but just to make you aware that even when a kid looks relatively healthy, there can be other things going on. Also, it says POTS patients see an average of 7 physicians before being diagnosed with POTS. And it says, what if you couldn't afford to see 7 doctors? What if you assume the first 6 doctors were right? So parents will go from doctor to doctor trying to figure out what is wrong with their child. And then there's the issue of the social idea of what a sick person should look like. And these I pulled down from the Dysautonomia website also. It says, just because you can't see it doesn't mean it doesn't exist. And we have a lot of people out there that look really normal. Have you ever seen somebody parking in a disability space and you think, why are they in a disabled parking space? They look fine. Well, you don't know what's wrong with that person. And this girl looks perfectly healthy, doesn't she? That happens to be my daughter, and she happens to have 3 diagnoses on that list. And it took years to get through everything and figure out what she had. But she also got through college, and we got her through that, and she's doing well. So we're going to talk about some confusing diagnoses when these kids wind up in a CPI investigation and they have conflicting symptoms, and what the child protection team doctor might be claiming that the parents have. The first one we're going to talk about is fictitious disorder imposed on another. How many people ever heard of Munchausen syndrome by proxy? Okay. This is the new DSM-5 diagnosis for it. And I want you to remember while we're talking about this today, this is not medical child abuse. Medical child abuse is much broader than this. But for fictitious disorder imposed on another, it requires a falsification of symptoms in the child. And the individual presents the child as being ill. So the parent shows up and presents the child with symptoms. And there's deceptive behavior, and there's an absence of an obvious external rewards. And the behavior is not better explained by another mental disorder, such as delusional disorder or another psychotic disorder. In other words, the parent doesn't have some other psychiatric illness that would better explain why they're presenting the child this way. So you have to rule those things out before you can say that the parent has fictitious disorder imposed on another. It would also require a psychiatrist to diagnose the parent. The parent gets the diagnosis, not the victim. Now I'm going to talk generally about medical child abuse, and we're going to get into that some more further into the presentation. Medical child abuse is defined as a child receiving unnecessary and harmful or potentially harmful medical care at the instigation of a caretaker. In this form of child abuse, a caretaker, most commonly the mother, engages in a pattern of behavior that results in a medical care provider giving care that the child does not need and which is or could be harmful. Well, think about it. If you have a sick child and you're trying to figure out what is wrong with that child, you may ask the doctor, can't we run some tests to figure out what's going on? Routinely, doctors draw labs. You're causing the child pain by sticking a needle in the child's arm. There's all kinds of tests that can be run to try to see what's wrong with the child. So this is kind of vague, okay? And I'm not saying I agree with this. Another confusing diagnosis is conversion disorder. And I'm not going to go through all of this, but it's functional neurological symptom disorder. And it's when somebody really believes they can't walk or they can't see, but yet there's nothing clinically to support that they really can't walk or see. And so you can look at all this. It's all online. It's been uploaded. We're not going to be focusing on that, but you will hear that in these cases. And I want you to pay attention, because if you get a case where it starts out with maybe Munchausen, and then the diagnosis changes to conversion disorder, and then it changes to somatoform disorder, something's wrong with the picture, okay? And it may not be something's wrong with the parent. It may be something's wrong with the way the case is being prosecuted or what the Child Protective Team doctor is saying. It shouldn't be a moving target. The next one that's a confusing diagnosis is somatic symptom disorder. And that's where they have one or more somatic symptoms that are distressing or result in significant disruption of daily life. They have excessive thoughts, feelings, or behaviors related to the somatic symptoms or associated health concerns as manifested by at least one of the following. Their symptoms are disproportionate to how they appear. They have a persistently high level of anxiety about their health symptoms. Has anybody ever known a friend that was always somatizing? They always had a physical problem, calling you all the time. It's this, that, and the other thing. They have excessive time and energy devoted to these symptoms or health concerns. They may be researching all the time on the internet. And although any one somatic symptom may not be continuously present, the state of being symptomatic is persistent. So the symptoms may shift, but they're always worried about something about their body. So this is another diagnosis that may come into the pot where the doctor says, well, now we think the child has somatoform disorder. Okay, let's focus now on medical child abuse accusations and how they happen. First of all, there's almost always a parent-provider conflict. The parent may have a child that has a chronic medical illness, and they bring the child to the ER because the child's in pain that night, maybe needs some medication, and the ER doctor doesn't see anything that the parent is referring to and thinks that the child is not really sick. And there's a disagreement that occurs. The parent may say, I want to leave, I want to take her to another place, and then the conflict's on. Usually the child has a complex medical issue or a rare disorder that isn't really apparent, difficult to pin down. The parent may have a history of doctor searching, and that is not unusual to go from doctor to doctor when you have a child with a rare disorder or something unusual. I think good parents do that. You keep going to a different doctor until you get clarification on what's wrong with your child, until you find the right specialist that specializes in one of these areas. Yet this is one of the things that will be used against a parent in a case that comes into our courtrooms on medical child abuse. The parents may make the mistake of telling the ER doctor they want a second opinion, or a doctor that they've brought the child to see and the doctor isn't in agreement with the diagnosis, that they want a second opinion. Think about that. Does anybody in here think that you're not entitled to a second opinion by a medical provider? I think everybody is. You may not agree with them, and that shouldn't be a reason for them to call the hotline. Treatment facilities are empowered to make these phone calls now. They can make a call that the parents are not taking the medical treatment that the child needs. And the child protection team doctors are key to the rise in these cases across the United States right now. The problem with medical child abuse is it casts a much wider net than Munchausen by proxy. Munchausen by proxy is extremely rare. All a child protective investigator has to do is throw that word in a probable cause affidavit, and the judge is going to go on high alert. They're going to win that shelter. Okay? I've seen that. I've seen Munchausen show up in a probable cause affidavit and then disappear as the case goes on, because it never really existed. Another thing that the child protective team doctor does if they get involved, like at a teaching hospital or they're called in to look at the child, is they will dispel the treating physician's decisions and what the treating physician believes that the child has. They will say that that doctor's incorrect or that doctor's a quack. The treatment that was ordered by the other doctor is often found to be inappropriate by the child protection team doctor or the treating facility that the child happens to wind up in. And what this is a transmutation of the parent's legal right to make medical decisions for their child into a broad medical diagnosis based on junk science. Because there's really no basis for medical child abuse other than an article written in the American Pediatric Association that was based on a retrospective chart review. A retrospective chart review is where they take a bunch of charts of patients that possibly had that diagnosis, and they start to review those charts to see what symptoms were documented. So there's never been any true research done to find out if there's any basis to substantiate that diagnosis. And if you think about it, think about medical child abuse. Do you know of any other medical diagnosis that has abuse in it? None. So this is something that has been brought up by child protection team doctors. And basically, if you don't agree with the doctor, you want a second opinion, okay, we're going to take your child away. And that's how these often start. They place the call, they place a hold on the child, and the child protective investigator comes in. Okay. Now, one of the other things we have to look at is how this happens. Physicians are not paid to research unusual conditions. It's very rare that a physician will want to go home and spend his evening researching something that might be wrong with your child. Okay? Sometimes they can't even order other tests until certain tests are done first. They may think that your child needs something done or this child needs a certain test done, but until they run through other tests, insurance or Medicaid won't pay for it. Or maybe insurance won't pay for it at all. So sometimes there are tests that can't be ordered. They have the time pressure of having to see multiple patients in an hour and get billing done and make a profit. A lot of the problem with healthcare today is that it's fractured. People specialize in one area. They don't have a lot of expertise in other areas. And remember, in one of the first slides I showed you, there are 7,000 rare illnesses. No doctor could know what all those are, and especially when it crosses different systems. If you look at something like POTS or dysautonomia, it crosses multiple body systems. So the kid may have a lot of stomach aches and problems with their stomach and be in pain. They send you to the GI doctor. But he's not a specialist in POTS. He's not going to pick up on that. So those are the kinds of situations that cause problems. Doctors are not paid to call other doctors and communicate with them about what they think is wrong. if the child's seeing multiple doctors. They may reach out to them, they may miss them, but they don't get paid to make those phone calls. Some of them will do it. Some of them just don't have time or they can't connect. And what becomes very apparent is it's very easy for a doctor to say, I've run the tests, they all came back negative, the routine blood work and whatnot, and there's really nothing wrong, and this is psychological. It's a conversion disorder, it's anxiety, it's not anything physically wrong with the child. It's much easier for a doctor to slap that diagnosis down than to spend a lot of time really listening to the patient and trying to figure out what's wrong with them. And this cartoon's kind of funny. It says, there are some things they don't teach you in medical school, and I think you've got one of those things because this doctor doesn't know what's wrong with this patient. And that happens a lot. They can't know everything. Okay, this is about parent profiles of parents accused of medical child abuse, and I'm going to skip through some of this because it's kind of redundant with my next slide that's by the American Pediatric Association. But you can read these. This is all in the outline. It talks about the warning signs, and it's the primary caregiver is most often the mother. Often they're educated, middle to upper class, and there's a whole bunch of signs and symptoms here. And, you know, if the parent remains calm or the parent gets upset, either way, these are signs and symptoms that the parent may be medically child abusing the child. So the parent can't win. Now we're going to talk about how the American Academy of Pediatrics came up with this diagnosis. They really refer to it now as indicators of possible fabricated illness in a child. And this article was published by the American Pediatric Association in 2013. And they say that the diagnosis does not match the objective findings. Well, often the right test hasn't been run to figure out what's wrong with the child. And remember, if it's a rare disorder or a chronic disorder, it may be coming on over time. Sometimes tests change over time, so the child may not have like a positive ANA test that shows that their system is changing. They may not have that. It may take several years for that test to change. You don't know if a laboratory test has been run correctly. Like, for example, when somebody does a 24-hour urine and they have to fill a container with urine for 24 hours and keep it on ice, and then they drop it off to the lab, you don't really know if the lab took it and put it in the refrigerator right away or if it sat out for an hour or two and whether the test results are correct. And these are things that could happen and you may not get the right result then. They say that the signs and symptoms are bizarre. The caregiver or suspected offender does not express relief or pleasure when told that the child is improving or that the child does not have a particular illness. Well, think about it. If you're a parent that you've had a child that's been sick for, let's just say 5 or 6 years, and you've been going to different specialists, and you believe that you have a good specialist that's treating the child, but it's Saturday, and the doctor's not open, and your child's very sick, and you go to the ER. And the ER doctor or the pediatrician who admits the child starts to tell you that your child doesn't have that illness. Are you going to believe him? Probably not. Especially because you know your child very well, you've been taking care of that child for 5 or 6 years, and this doctor just met them. You may have volumes of medical records, and this doctor is probably not going to read them. They're not going to have time to do that. So that's one of the ways that they measure whether a parent is suspected of possible fabricated illness in a child. Another thing is inconsistent histories of symptoms from different observers. They will start looking at the medical records. They will see if the medical records are consistent with what the parent's telling them. How many people have ever had a medical record on themselves that have something documented inaccurately? Have you ever had a medical record, right? Okay, I have. I've had a brain tumor before, which was benign. I was blessed with that. But when I went to pick up my records, it said I had a history of cancer of the brain. And I was like, are you trying to kill my life insurance policies, you know? So I went back and I demanded that they changed it, but I'm an aggressive person that way, and most people wouldn't know to do that, and I knew to read my medical records, and I made them make an addendum in the record that said that I've never had a history of brain cancer. It can happen that easily. My chart also says I'm right-handed. I am not right-handed. I'm left-handed. I never told anybody that. So it happens every day. The next thing is caregivers insist on invasive or painful procedures and hospitalizations. Well, let's talk a little bit about that. If your kid is constantly sick and not doing well, and you read about the illness that your child has, but you know the doctor hasn't run all the lab tests or tests in general that should be run, it's quite common for a parent to say, shouldn't we run this test next? Shouldn't we do this to rule this out? Because if your child has a progressive illness, you want to get to the bottom of what's causing it to see if you can stop the underlying condition from getting worse. So it is not unusual for a parent to ask for procedures to be done and for labs to be drawn to rule out the underlying cause of the illness and to see if they can get their child some relief. Another item that they have is caregiver's behavior does not match expressed distress or report of symptoms, that the caregiver can be calm. They also don't like it when the caregiver gets excited and angry. So a parent can't win on that one. They will tell you that the child only acts that way when the parent is present in the room. And I think that everybody knows that sometimes kids can be more dramatic or more free with their behavior when they're comfortable with somebody. Kids may even do it to get attention from their parents, okay? But that's not necessarily a symptom of the parent engaging in medical child abuse. Another symptom is that the sibling has or had an unusual or unexplained illness or death. Sensitivity to multiple environmental substances or medicines. Many children that have rare illnesses or chronic illnesses have a lot of sensitivity to environmental factors and to medicines. That doesn't necessarily mean that the parent is engaging in medical child abuse. Failure of the child's illness to respond to its normal treatments or unusual tolerance to those treatments. Again, many of these children are very sensitive and can't handle some of the treatments that are being given to them. They have to have lower doses of medications in order to tolerate them. And then they also look to an extensive unusual illness history in the caregiver or caregiver's family. The important thing to note here is it doesn't say that the parent or that the child has to meet so many categories here. It just lists them, okay? Because they did a retrospective chart review, and this is what they came up as common elements that they were looking at. And they wrote this article. So it doesn't say that if the parent or the child only exhibits one of these symptoms, that this fabricated illness or medical child abuse attaches. It doesn't say that you have to have 5 out of 12. It doesn't specify that. And it doesn't specify whether or not the child has an actual illness that the doctor can identify and say, yes, this child has this illness, but I still think the parent is engaging in medical child abuse because the parent is wanting more tests done. So it's kind of slippery. And as I pointed out to you, it's not a diagnosis of exclusion. It doesn't provide for them to rule out other diagnoses, to make sure that the child doesn't have a physical diagnosis that really meets and explains the child's symptoms. What happens with this is once this starts and the accusation is made, any further procedures on the child and medications may be deferred, which may adversely impact on the child. There is no diagnostic test that will establish medical child abuse, so we don't know whether it's just the CPT's opinion. There's not a blood test that can be run to say this is medical child abuse because this blood test is negative. Often the CPT doctor recommends that there be a trial period where the child is separated from the parents, and that is a big concern. And I'm going to be addressing that later in the presentation also. There's an absence of scientifically chosen indicators. There's a threshold of certainty for actions on the diagnosis that's not explained. One of the things that these doctors rely on heavily by the American Pediatric Association is that there's inconsistencies in the medical records. And, doctors, you can go to a doctor after having back surgery, and the doctor will say, "How are you today, Mrs. Smith?" And you say, "Well, I'm pretty good. How are you?" And he writes down, "You're doing well." Okay? I used to do Social Security disability cases. That happened so many times, I can't tell you. The patient would tell me, "I'm not feeling any better." I tell the doctor that, but it was written down that they said they were feeling fine. And doctors want to make us better, and that's what they're trained to do. And so if they hear you say you're okay, then that may be what they wrote down. And there's as I said, no requirement that there's diligence in making sure that there's no other diagnosis that better meets the child's symptoms. And as we talked about already, there's errors in medical records, and that's very common. It happens every day in the healthcare system. A parent's misstatement of a medical history of a child should not be equated with an intentional misrepresentation. Another thing that can happen is one doctor can read a medical test and say that it's a negative result, and another doctor can read it and say it's a positive result. And I have seen that happen with my own daughter's history, where she had a tilt table test done, which is very important in diagnosing POTS. And the doctor that did the test was a cardiologist at a very good hospital who said that he was starting to specialize in treating patients with dysautonomia and POTS. So when he said that it was a negative tilt table test, we believed him for over a year until I got her to two specialists over the years that specialize in dysautonomia and POTS, and they both told me that the doctor had absolutely misread the test, and it was absolutely a positive test for POTS and dysautonomia. So it can be very confusing. And like I said earlier, lab values can change over time as the underlying disease progresses, and then things start to change. So they may not be where they're positive values that something is wrong initially, but over time, when you rerun some of those lab values, they may change over time. And now I'm going to have Mr. Kelly talk about evidentiary issues.
So, how many people here are volunteers for the Guardian program? Volunteers? Well, this presentation is for you, sir. There are evidentiary standards in the state of Florida that you need to be aware of. And so this portion of the presentation is really just an awareness feature. There are two evidentiary standards right now regarding evidence of experts, the Daubert and the Frye. But the closest I could get was Dilbert and Frye. So we're going to talk about those. The Frye standard was used in this state for a really long time. It was really simple for lawyers to get to. You put your expert up there, you'd say, "What do you think?" They'd tell you. And then they'd say, is your opinion, or the test, generally accepted in the field of whatever they talked about, medicine, engineering, psychopharmaceuticals, whatever. And they'd say, "Sure." And the judge would say, "Okay, I can give this expert weight." And then something happened. 2013, the Florida legislature got involved and said, this is really too simple and we need to adopt the federal standard, the Daubert standard, which requires more questions to be asked. Is it based on sufficient facts or data? Is the testimony the product of reliable principles and methods? Will the principles and methods be reliable to specific facts in the case? And there's more. It goes on for a while. There's been a lot of controversy about that versus Frye, because after the legislature told the Florida courts that Daubert was the new standard, the Supreme Court said, maybe. You really don't tell us how to run our shop, and we'll decide if it's Daubert or Frye when we get to the right case, which we now have a case, and it turns out it was not the right case, but tobacco company case. They went through a trial. It went through an appeal with the 4th District Court of Appeals. 4th District said, we are a Daubert state. Florida legislature or statutes are presumed to be constitutional, and that's where we are. The lawyers who didn't like that said to the Supreme Court when it got up to there, we're still a Frye state because you haven't said we're not. And then, unfortunately for them in the argument, the justices looked at what the test was, and it was a tobacco company test. It was done on a product, one test that was run back in the 1950s to tell us that tobacco wasn't that bad, ignoring everything else. And both of them said, or the justices said, this test would not pass Daubert or Frye. So I don't know why anybody listened to it. It's just not enough. For me, and there's the case cited at the bottom for anybody who wants to look it up. And it was in the Bar News maybe a month ago. What it really comes down to is vigorous cross-examination of the expert and the test that they are running. If you have a local expert, which we do, come in and say, I've looked at the facts and under the principle of whatever, this is my opinion. But then the door is open. How do they really know? The standard that your profession uses is subject to then being cross-examined. What test are you talking about? Who ran it? When was it run? How does it apply to the facts in this situation? How is it different than the facts of this situation? How does it apply this way? How does it not apply that way? On and on and on. A vigorous expert cross-examination is what's needed here to really call the shot. It's that way under Frye. It's that way under Daubert. If the person challenging, and I mean the lawyer, the expert opinion doesn't like what they've got to say, you go after them, because that's what you do. If it's a defense witness, the state's going to go after them. If it's a state's witness, the defense is going to go after them. And the opinion holds up or it doesn't hold up. The judge makes that decision. That's their job. And that's basically Daubert versus Frye. It really doesn't matter if you do your job right.
And what we've given you here in the presentation is 90.702 that talks about the statute about testimony by experts. And they also talk a lot about a reasonable degree of medical probability, and they'll ask the expert, the child protection team doctor, is that your opinion within a reasonable degree of medical probability? It's a very simple question, and it's a very easy answer. They're always going to say yes, okay? But a CPT doctor is a pediatrician trained to recognize child abuse, broken bones, things like that, not to recognize rare disorders of 7,000, okay? And these are Mike's slides where he says the parents did it. That's the CPT doctor saying the parents did it.
Yeah, to go back to that one just a little bit.
Yeah, you got a case after that too.
I just wanted to expound on that a little bit, because some people look at these images and will think to themselves, I'm seeing an image of an entity here whose opinion is infallible, who is not to be questioned and represents everything good and reasonable in the universe and must be followed. And the other one is God. God is a subject of great debate among human beings since man could think. Who is God? What is God? Where is God? Who am I in the grand scheme of things? Does God even exist? Reasonable questions for logical minds, and they've come up with every answer you can imagine, and then more. There are people who look at a CPT doctor and will do whatever they say, with no questions, with none of what Ms. Salisbury's been telling you about. Could it be something else? It's never even considered. And even though I'm aware of state lawyers who have questioned the validity of what a CPT doctor has said to them, the people who follow them do not. And some administrative folks say, go with what your client tells you to do, put your legal expertise in your back pocket and you just hold on to it for comfort because we're not going to use it today. That leads to some unfortunate consequences, like the next slide.
Okay, and this is not about a medical child abuse case, but this is a case of NJ versus the Department of Children and Families. It happens to be a second DCA case from 2014. And in that case, the court, this is directly from the case, the determination of child abuse by the child protection team doctor was a subjective opinion of abuse and disbelief of the parent's version of events, does not meet the competent substantial evidence standard. Dr. Smith's testimony alone was not legally sufficient to support the trial court's adjudication of dependency, and it reversed the order adjudicating a child dependent when the only evidence of violence was the opinion of the child protective investigator, in that case. And I believe that case dealt with Dr. Smith, I believe, was in one of the cases where she was the only doctor to testify that it was child abuse. This was not a medical child abuse case, but 3 other, I think, doctors testified that it was not child abuse, what happened to the child, and that I think it was about a bumbo chair, that the child had been sitting in a bumbo chair, fell, and became injured, and the other doctors all felt that the story that the parents gave about how it happened was credible. The one CPT doctor did not find that their explanation was credible, and that's how this wound up going all the way to trial on a dependency case. And so the second DCA found that she was, that wasn't enough to find that there was a dependency and reverse that case. Let's talk about child protective investigators. Been a lot of turnover. I've been doing this a long time, and I used to know child protective investigators that had been doing it a long time, and I knew some child protective investigators that could establish a rapport with a family and tell them that, you know, we're going to have to take your baby, but we're going to help you and get you some services, and the family would still respond to that person and appreciate them and be able to work with them. And a lot has changed over the years. We have a lot of child protective investigators who are overworked. They are poorly paid. They are frequently short-staffed. They can't retain staff. So there's a lot of turnover. They're poorly trained. They have a lack of experience. Some of them are so young. They've not really had any experience with kids. They could be fresh out of college. They have a lack of understanding of complex medical conditions and rare diseases. They don't know anything about these diseases. They also fail to contact the child's treating physicians, because the way this goes down is if the parent is at the hospital with the child and the child's admitted, and the parent doesn't want to follow the treating physician who has admitted the child's recommendations, wants to take the child to a different facility, wants to take the child somewhere else for another opinion, the abuse call is called in. They will call the CPT doctor to the hospital to examine the child. The CPT doctor will examine the child, examine the records, and often meet with the parents under the guise that she's there to get information about the child. What the parents don't realize is that she's really part of the investigation in the case that's being built against them, okay? Or he. And once that CPT doctor says that we think this is either Munchausen, because they still use that term even though it's really fictitious disorder by proxy, or we think that the child has a conversion disorder and the parents aren't accepting that, or we think this is medical child abuse, then the whole machine starts running. And here comes the dependency case. So at that point, the child protective investigator is not going to be contacting the child's treating doctor to get more information. It would be up to the CPT doctor, who usually will not give any validity to the treating physician and what his opinion is. So at this point, the child protective investigator doesn't even bother to call the child's real doctor that's treating the child out in the community. They will rely on the CPT doctor, who is not an expert. That is the one takeaway I want you to take out of here today. Realize that any child protection team doctor is not an expert in complex medical conditions, and they are not qualified to say that that child does not have the disease. That an expert in that field has diagnosed that child with. But they will do it. They will get on the stand and do it. We know that when we switched to the new methodology, all kinds of things started happening in Florida. It's a huge checklist. It's problematic. It cast a much wider net to bring kids into the system. There is limited, if any, objective investigation after the CPT opinion is rendered. The child protective investigator may not even bother to call the child's teachers, the child's neighbors to see, is this family really crazy? What's going on here? Are they good parents? Are they not good parents? Is the school having problems with the parents? Is the school having problems with the child? Is the child in school? Is the child doing homeschooling? And we have to remember that child protective investigators have a tremendous power to remove children upon probable cause, a statement that can be loaded with hearsay, opinion, and inaccuracies. I have had cases in the last year where we've had things put into probable cause affidavits that says, a dead body was found on the couch. Well, that'll get a judge's attention, won't it? And then we find out that nobody died in that house, okay? But by then, the shelter's already happened, okay? So then it's hard to start backing up on these things. And so if it's loaded with hearsay or it says the parent has Munchausen disease, even though we know that's not a valid diagnosis anymore, it's going to get the judge's attention. And most judges are going to shelter based on a statement made by a CPT doctor, even if there's not a full report yet. So these are the types of things we're up against. And the fact that the courts have insufficient times to have evidentiary hearings on every shelter. And typically, we all know that the department has a lot of lead time. They know when they're going to shelter a child. They're working on their petition and they're getting ready. The parents don't have a lot of lead time. They usually get told that they're taking the child now and the hearing's tomorrow. They don't even have time to hire a lawyer. And the last thing is that courts want to believe that the department is doing the right thing and doing what's in the child's best interest, so courts tend to take what the department says as valid and true all the time. I threw this in here. I don't know if you can read it. It's a little bit blurry. This is a social worker testifying in court, and she says, we believe the parents may have some emotional or mental issues. They have severe outbursts when we took the children, and they're constantly hostile towards us. Yeah, they don't like that. I had a client once that when they went to take her baby, the carriage had fallen over, and it happened on 2 different occasions, and baby got hurt a little bit. And she took the child to the hospital, and sure enough, they took the baby. And when they showed up at her house, she became so upset that she crawled into the bathtub holding onto the baby. And she was arrested for obstruction of justice for that. I think probably that could have been handled a little bit differently. But I always remembered that happened, and she recently came back into my office, and it's been years, so I didn't remember. And when she came in and she finally started going over the facts, I said, oh, you're the lady that climbed into the bathtub and got arrested. She says, is that how you remember me? I said, I remember those facts. It's very, very different. But yeah, that is what happens. People freak out, and they don't want their children taken away from them, and they want a chance to try to redeem themselves and work with the department. But we know that once a decision is made to shelter, it's over for the parent. Okay, let's talk about the problems with DCF involvement when they become involved in a medical child abuse case. What happens is that in order to protect the child, often the CPT doctor, if she determines that this is medical child abuse and that there's nothing wrong with this child, and the rest of the medical team or the hospital agrees with her, any further assessment or determination of the child's illness will stop. And so sheltering a child due to suspicions of medical child abuse can ultimately hurt the child if it delays them getting more testing and whatever needs to be done to help them. The possibility of facing the allegations of medical child abuse may have a chilling effect on seeking medical treatment. There's emotional trauma to the child when the child is separated from their family and friends. And this is a big one because generally in these allegations, the department doesn't want the child, or the CPT doctor recommends that the child should not have any contact with family or friends, and that they want to keep the child isolated because they want to see if the child will improve. There is a parental stigmatization of child abusers. These could be good families in the community, and they don't want people to know that their child was taken away and that they're being accused of child abuse. It can adversely impact on the child being accepted into an appropriate facility. If there's a facility that a child needs to be put in for rehab or further treatment, once that diagnosis of fictitious disorder by proxy or medical child abuse hits the medical record, some facilities will not accept the child for admission. They don't want to be involved in that. So it can ultimately adversely impact on the child's correct diagnosis. I want to talk a little bit now about supporting and advising the parents in best practices. First of all, I think that anybody that has a child with a chronic or a unusual medical condition should keep a notebook of their child's medical records and be ready to share that notebook with any doctor that they're taking the child to. Most doctors will not want to read that whole notebook. So I also suggest that they have a letter from their treating physician that spells out what is wrong with the child, and from many other supportive sources, like if the child's in physical therapy, maybe a letter from the physical therapist about that the child's been coming to therapy regularly, or psychotherapy, that the child's been in psychotherapy regularly, that they have that with them whenever they take the child somewhere else, even if it's an ER. I think it's very important to have an overview of the relevant information of 1 to 2 pages to provide to the healthcare providers. Because if you have a stack of medical records, the doctor is not going to have time to read those. But if you bring them with you and you have an overview that is based on what's in the medical records, he can read that overview quickly and he can get up to speed on what's in the medical records. And if he has any questions, he can say, can you find where this test was done in the medical records so I can verify that for myself? They need to maintain decorum with healthcare providers, hospitals, and schools. And I happen to be on a website on Facebook that's a closed website for parents that have children with POTS and dysautonomia. And I can't tell you how often they are so frustrated when they have to take their children to the hospital to be seen in the ER. Maybe the kid has a bad migraine or is very sick and in pain and needs a shot, and the ER doctor doesn't want to do it. And I have responded, fly under the radar and get out of there. Because if you challenge the doctor, there may be a call to DCF and they may be taking your child away. So it does have a chilling effect. They need to practice assertiveness skills and not get aggressive and lose their control with the healthcare provider. And it's tough because some of these people are trying to work and take care of a sick child that maybe is so sick the child can't attend school. They need to have stress management in place for themselves, and they need to have a support system. And so many of our parents in our courtroom don't have that. They need to be consistent about getting their child's medical records and keeping them. They need to read them. And if there's something that is not correct, they need to go back and ask that that correction be made, especially if it's something like I had in my record. That's not something you want in the record if it's wrong. Sometimes I've read medical records where it wasn't even the right patient that they documented something on. And when your doctor says to bring your recent labs, don't bring all your lab puppies with you. Okay. I'm going to make this all drop in here pretty quickly. This is 39.301 subsection 5AB. And this is the portion of the statute that deals with an investigation. And when parents first get that call that they're being investigated, they often think that if they just meet with the investigator, they can just explain it away. And sometimes they can, and sometimes they can't. But what they need to know is their rights, and I highly advise parents that they should hire a lawyer that knows the law at the investigative phase. And that they need to know that when the investigator gets there, what frequently happens is the investigator will say, well, I'm investigating a case and I need to get some answers from you and I need some information. And they'll start right in, and they do not tell the parents their rights. And they're required to under the statute. They're required to give them their name, and they often give them their card or their name, but the parents either don't write it down. They need to tell them the purpose of the investigation, and they need to tell them that they have a right to their own attorney. And they also need to tell them the possible outcomes and services. What I have run into over the last several years is that they tell them that we can't tell you what services we have until we're done investigating. Well, their investigation can take 90 days sometimes. And there's no services being offered in the meantime, which I don't believe. I think there are services that should be offered right at the get-go if there's any way to stop a removal and not have to have a removal. And the other thing that they don't always tell them is that they have the right to video or record the whole investigative interview. I routinely do that. When people hire me, I set up a video camera. I have the investigator come to my office, and I ask them those questions first, and I want to know why they're there, what they're investigating, and then I will let my client start answering questions. And I video record the whole thing so that it cannot be spun, because so often people say one thing and it winds up being a different thing in the probable cause affidavit. The other things that we tell them is that they should hire a lawyer sooner rather than later, and they should hire a lawyer who's experienced in dependency law. So often they will call a family lawyer who maybe has no experience with this. They should be mindful of everything stated, text, emailed, posted, etc. The child should be represented by a lawyer. Parents who can afford it should hire a lawyer for their child or their children. Parents have a constitutional right to make medical decisions when there are two different opinions between different doctors. It is up to the parent to make those decisions. It is not something to remove a child over. The other thing that parents should not do, which some of them like to do this stuff, they should not blog about their child's health care and document it all on the internet. They should not post pictures on Facebook about their child, particularly if their account is not secured or private. They should not use Instagram to document their child's health care. They should not use GoFundMe pages for their child's health care, which is sad because maybe some of them need that money, but it will be used against them in a dependency case. They should not be overly demanding with the school system on IEPs and 504 plans because that costs schools money to do those plans and to put in services. They should not be confrontational with physicians and healthcare providers. And the biggest thing is they should not believe that the CPI or the CPT doctor is their friend and confidant. They should not meet with law enforcement until after they have had consultation with an experienced attorney. If law enforcement wants to meet with my clients, I will not let them meet with them until they have talked with a criminal attorney. And I was going to play for you the clip from Terms of Endearment, but I can't get it to play. It's a very old movie from the 80s where the mother goes out to the nurse's station and is screaming and yelling that her daughter is dying of cancer. And it's an adult daughter, but she's screaming and yelling, give her the shot now, and she starts screaming and yelling. And all I could think is, in this day and age, security would be called and the mother would be arrested and removed from the hospital. But it's normal for people to get upset when somebody is really sick like that. How many parents or people in here are parents and consider themselves to be a mama bear or a papa bear? I always say, you can come after me, but don't go after my kids. You know, if my kid is hurt or something, I want the right thing done for them. And Mr. Kelly should have raised his hand. He's a papa bear. Okay, let's talk now about the impact on the child. They can be isolated from their family and friends. They can be kept in a hospital room. They can be sent to medical foster care, and they're not allowed to have visitation with family, friends, maybe even their school friends. They're not allowed to have any contact with anybody sometimes. It can disrupt their daily routine, and they can possibly have to change schools regardless of whether they were being homeschooled or not. It can disrupt their continuity of health care where they maybe can't see their same health care provider. They can have a decline in their health because of being sheltered and not being able to resume their treatment. They can be traumatized by the removal. We talk about trauma constantly now in dependency law, trauma, and the trauma the child suffers. What about the trauma of removal? We need to look at that more carefully. We need to try to work with families and try not to remove when we don't have to. Children can learn to distrust the system, case managers, law enforcement, and new physicians, especially when they are told, we're going to take you, we'll let you see your mommy later. And then it doesn't happen. They can be denied treatment from an appropriate facility because of the medical child abuse diagnosis, as I told you earlier. And it basically taints the well, and the other facility says, we don't want to be involved in this. And I have read some cases over the United States where it has resulted in death from a lack of appropriate treatment for the child. The impact on the parents, again, is the taint of having to consent to a dependency. Sometimes people will say to me when I'm representing a parent, well, can't you just get them to consent? Well, not if they haven't done anything wrong. Who wants that on their record as a parent? Who wants that on their record? The termination of parental rights is a terrible stain on anybody's reputation. We know that in some of these cases, the department has to report it to law enforcement, and the next thing you know, they're trying to arrest the parents, so then they have criminal charges on top. Sometimes a case can be dismissed after months of being kept from contact with the child, but it still hurts because it's been a long time. There can be a loss of family savings due to legal and expert witness expenses. And I'm talking about the people that can afford to hire an attorney to do all this. What if they don't? What if they get me court appointed? There's not a lot of money coming from the state to hire experts and whatnot in these cases. So it can be very difficult to defend people then against these types of cases. They can lose their employment because their employer finds out about the allegations, even if it's not been proven and they haven't been to trial yet. And as I said, it can have a chilling effect on a parent trying to get the child health care in the future. I am going to now just go over a little bit more on the Child Protective Investigator's role. Just to generalize, they need to do more to investigate and not just rely on the Child Protection Team doctor's opinion. But I think that they're being told from the higher-ups in the department that once they have their expert, the CPT doctor, that's all they need, and they have to follow their expert's opinion. But the CPT doctor is not an expert in a rare illness. Okay. This is where the guardians come in. How many guardians do we have in here? How many people work for the Guardian Ad Litem program? Okay. The white hats on the tables are for you. Please take them. They say family preservation on the front, and I need you to wear the white hat because that's Olivia Pope from Scandal, and it says, one who is admirable and honorable, that's you, and a mark or a symbol of goodness is the white hat. So I'm going to need you to wear the white hat, and what I'm going to ask you when you get a case like this, I want you to ask yourself, is it in the child's best interest to be isolated from family and friends? That's very important. That's very traumatizing to a child to be isolated from their family and friends. And that is one of the first things that happens. Is the child's condition improving or declining since removal and separation from the family? Go see the child yourself. If the child's in the hospital or in a medical foster care home and they tell you, oh, the child's doing much better, go see the child yourself. You're all smart people. You'll know if the child really looks better or not, okay? And then ask for the medical records and whatnot to see what's going on. Don't rely on what you're told. Go see the child. Is there any objective evidence of the parent harming the child? Remember, in fictitious disorder by proxy, usually they would put the child in a room where it's being video recorded, and they would catch the parent doing something on video, okay? If they don't have that, then what's going on here, okay? Or is it just that they're using the broad medical child abuse diagnosis? But usually it's going to be on video, and it's fictitious disorder by proxy is extremely rare. You will be lucky to ever see one in your lifetime. I happen to have worked as a psychiatric nurse practitioner at Sarasota Memorial Hospital for 4.5 years, and I carried a beeper and I consulted all over the hospital on medical surgical patients, and I saw 2 fictitious disorder patients where they were harming themselves to be hospitalized in all that time, and that was it, and that was over 800 beds. And I feel fortunate that I had that experience in seeing them and helping to identify them, but it's extremely unusual. And then ask yourself, is it acceptable to traumatize a child in this manner? Is there documentation by licensed physicians supporting the diagnosis of the complex medical condition? Think about that. If the child had been seeing a specialist, that's what they do. They're a specialist in dysautonomia, or they're a specialist in POTS, or Ehlers-Danlos syndrome. And they have documented that the child has this disease and this is what the proper treatment is. Then why would we shelter a child because the Child Protection Team doctor doesn't think that's accurate? We have 2 competing doctors with 2 different diagnoses, and the licensed medical doctor who's the specialist hasn't had his license pulled from him. So why are we doing that? This is a parental decision. Is it likely, remember they said that the parents might have, manipulated, that's one of the things on one of the screens, the parents might have manipulated the doctors. Ask yourself, is it possible that this parent is so talented and so manipulative, and we know parents can be manipulative, is it possible that they fooled that many licensed physicians that the child has seen, okay? And then I'm going to ask you to wear the white hat and do the right thing. And when you're in court and you know that what is going on does not seem right to you, to keep that child isolated and to keep the parents from the child, and the child is sad about it, and that you really don't have any concrete evidence, or you have two competing doctors who are saying different things, speak up so that this child is not further traumatized, and wear the white hat. I'm going to talk a little bit now about what judges can do. Judges need to make the department prove their case. They need to set these cases quickly and get them moving. They need to look for the red flags as to the child protection team doctor. They need to recognize that that child protection team doctor has little to no expertise in treating complex medical illnesses. If the doctor gets on the stand and says, I've never heard of this illness before, but I've researched it, that should be a red flag, okay? If they're researching and having to learn about this illness for the first time, they don't have any expertise in it. They may be citing authority and relying on information that's out of date. I've handled cases where they were relying on textbooks from the 70s. Medicine's moving faster than that. And some of the diagnoses that were valid in the 70s are no longer considered valid. Just like Munchausen disease is not the proper diagnosis anymore. It's changed. If they don't know what edition of the DSM we're on, that's an issue. We're on the DSM-5, okay? Back when I was doing a lot of psych nursing, we were on the DSM-3, so we've come a long way. It's changed a lot. And if the doctor doesn't know which edition we're on, that's an issue. The other thing is you have to look at the CPT doctor is basically diagnosing the parent with medical child abuse when the parent should be diagnosed by a psychologist or a psychiatrist who's capable of diagnosing them, not a pediatrician. But they want that power to make that diagnosis. And I just covered that. Formulating a psychiatric diagnosis of a parent when they're not qualified to do so. You'll often find that the CPT doctor only briefly called the treating physician or really didn't connect with them at all. They will have probably reviewed some of the medical records and found everything that's wrong in the medical record to prove that the parents have not told things accurately. They like to judge the credibility of the parents. Think about that. If you interview somebody often enough and ask them, well, do you think it could be this? Or have you ever thought it was that? Eventually parents say, well, maybe it could be, but I don't know. So they are making an opinion about how credible the parents are. That is for the judge to make that opinion. They want to judge the parents. That is up to the court. They are involved often in interrogating the parents without disclosing their role as a contractor of the department. And remember, they are being paid to render that decision. They make money when they render these decisions on these cases. There's a profit to it. Recognize the departments and the CPT doctor's spin. They often will not include anything positive about the family, but will put everything negative that's happened into the probable cause affidavit and into the allegations. The judge should require that the department bring a true expert in the correct field of medicine with proper qualifications and expertise in treating the illness before the court for testimony. It should be somebody that has expertise in that field and not somebody that has done research on it. They should also inquire of the expert or the CPT doctor, which I don't consider them an expert, how long will it be necessary to deny the family contact in order to note an improvement in the child? There should be a limitation set on how long that experiment is going to go on. They should hold the purported expert's feet to the fire and inquire as to how the child's health improvement will be objectively measured. How will we know when the child is better? And if the doctor can't answer that, then the doctor obviously shouldn't be allowed to keep the child separated from the family that long. They should recognize the trauma, as I discussed earlier, to the child in isolating the child from family, and they should not accept that recommendation of isolation. That cannot be in the child's best interest. We always have supervised visitation. We have other options. The judges should support the constitutional law of the parent's right to make medical decisions when obtaining conflicting recommendations and when doctors disagree as to the recommended treatment, testing, etc. And they should recognize that the reporting healthcare provider, and that may be the hospital, it may not be a CPT doctor, the person that called it in, may be seeking to enforce their recommendations, and they may not like the fact that the family wants a second opinion or wants to take the child out. That is not a neutral opinion. They may be angry that the family went against them. I'm going to point out a few references to you that are really helpful. Maxine Eichner wrote an excellent law review article. For any lawyers in here that ever get a case like this, you should absolutely read this law review article. It's called Bad Medicine, Parents, the State, and the Charge of Medical Child Abuse. I have a copy of it. If you can't find it, email me and I will get that to you. Another good source of information that I found was Mary Hollinger. She's an RN, and she has, I think she's on the Mito website for mitochondrial disease. I believe she has a child that's sick also, and she has some very good PowerPoint presentations on complex medical needs and medical child abuse accusations. And there's some more references for you there. And I just want to thank you all for attending today. If you have any questions, we'll be happy to try to answer your questions. Thank you.
I have a question. Do you have a... Oh, I can shout too. So. When you were talking about the rights to a second opinion and these long-term illnesses, what are we to do in situations that are more exigent than that? Where we're talking about exigent, like it's an emergency situation where, you know, they're saying the child is having these seizures because of this and we have to immediately perform surgery, and you're saying this is not the case, and then they call in DCF. You know, when it's a long-term illness, I'm sorry if I'm not describing it well, but like when we're in an emergency situation, you're disagreeing and they call in DCF. Do you have any recommendation as to how to handle the emergency situations a little bit differently than these long-term illnesses?
I think that what you're talking about is an appropriate use to shelter a child. If there is, the state has a preferred course of action. I'm reading this from Maxine Eichner's article. A preferred course of treatment, and it must be compelling in the sense that all the child's medical doctors agree that it's the correct one. If it's something like that and the parents are saying no, or the child needs blood, something like that, and the kid's going to die, then yes, shelter. That's when it's appropriate. There are 3 circumstances in her article, her law review article, that are laid out when it is appropriate, but they're extremely rare. We don't usually see that. But when you see that there's a disagreement between doctors of how the child can be treated and there is no emergency, that should not be a removal.
This is not really a question, it's a comment and a suggestion, which is that another role of the judge or perhaps the guardian ad litem attorney or the parent's attorney is to absolutely, in the very beginning, request the appointment of an attorney ad litem. The guardian ad litem program may err on the side of trying to protect the child without necessarily vigorously advocating for what the child's expressed interests or legal interests are. And I believe an attorney ad litem has much more power to go in, track all these things down.
I agree with you.
And they can be appointed.
I agree with you. That was in the slide, the presentation.
I know
to
you
lawyer
said that the parent should look for it right away, but I think that the court system should appoint one right away.
I agree with you. The child should be represented.
Hi, I just want one point clarified. I know your presentation was mostly on medical needs, but you did mention parents should not push too hard for IEPs and 504s because of the cost to schools.
No.
And okay, so could you clarify what you were meaning there?
No, I wasn't saying that. They need to watch how they interact with the school about that. They need to, exercise decorum about that. Sometimes parents want a lot of things done for the child, and they need to work with the school and not make it more difficult. If there's something that they can do to work with the school, then they should do it. But they need to watch what they do, because that does cost the school money. And as an example, my daughter was in college, and I did ask for accommodations. I helped write up a paper. I got it to her doctor because I happened to know what she needed. And the doctor was very gracious and signed it for a small fee after I wrote it up. But, and it did get her accommodations in college where she was able to take less classes, take her exams alone, and get the things that she needed. So I think that you have to advocate for those things, but you also have to be, diplomatic about it. And they need to be careful about that, because I think some of these parents are under so much stress that it's easy for them to come off the wrong way and then antagonize somebody, and the next thing you know, the school could be calling it in.
How would you encourage a parent or a caregiver who's using an alternative medical provider or an unlicensed medical provider to seek treatment from a licensed specialist?
All right, ask me that one more time. You're talking about alternative medicine?
Right. So if you have someone whose child is being seen by an alternative, a natural, like a homeopathic medical provider, or in Florida, a natural medicine provider, how would you encourage them to seek treatment from a licensed provider, and how would you encourage them and counsel someone to do that?
That's a difficult question, because I was trained on a medical model, so I was very anti-homeopathic. And as the years have gone by, I think we've gotten more homeopathic. And as long as it's not going to harm the child, I don't see any problem with them seeking that type of treatment. But if they have a medical doctor that's saying that the child needs a different type of treatment, or it could be life-threatening, then I don't think they have a choice on that one. But I think they have the right to seek homeopathic treatment, and sometimes you can do a combination of both and get benefit from both. Thank you. That's it. Thank you so much, and take your white hats, please.